Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about a case heading to the Supreme Court of Canada about a new tort, the tort of family violence. The case is called Ahluwalia and Ahluwalia. The husband in the case has faced criminal charges for assault and uttering death threats against his wife. And based on the evidence in the family law case, the wife was a victim of physical and emotional abuse. In addition to the claim for separation, the wife brought a novel claim for damages for the tort of family violence. In a groundbreaking decision, the trial judge awarded the wife $150,000 in compensatory and aggravated damages and punitive damages for that new tort that she found of family violence. She found the marriage was violent and that the damages suffered could not be compensated through with spousal support. The court found that it's important for our law to recognize the tort of family violence because abuse is a social issue that's been criminalized and requires a corresponding civil remedy in family court. However, the Court of Appeal overturned the decision, finding that the trial judge made an error in creating a new tort solely on the grounds of family violence. The appeal court held that a new tort should only be created where there's a harm that's urgently demanding of an unavailable legal remedy, and the court also took issue with the trial judge's approach to crafting the new tort. The issue will now be heard by the Supreme Court of Canada. Here today to talk about the case are two experts, family lawyer Anthony Martin and law professor Stefan Serafin. Thank you both so much for joining me today. Anthony, let's start with some of the background of the case. What more can you tell me about this case?
Sure. So the parties were married for about 17 years. They migrated from India to Canada. They have two young children. And during the course of that marriage, the wife reported a long history of domestic violence, various forms of control, various forms of physical violence. Following the parties' separation in about 2016, the husband commenced an application in court. The wife responded to that. Subsequently, as you indicated earlier, the husband was charged with various criminal offenses. What's interesting about this case is that the wife actually amended her pleadings several years after the application was commenced to make the tort claim that we're talking about now. She didn't call it a family violence tort, but she did amend her claim, and she was self-represented. There was an 11-day trial, and after the 11-day trial, the court decided that there was, of course, this finding of family violence, and that she would be entitled to $150,000 in damages.
So, Stefan, I think what might stand out to people about this is this whole notion of creating a new tort. And this is sort of how the common law works. Judges can create and find new torts, but how often does that actually happen? And sort of maybe you can provide some context about why the law works that way.
Right. So, first of all, thanks for having me on to talk about this. So, just to be clear, right, the novel creation of novel torts is actually quite exceptional. Common law, yes, it's judge-made law. Our tort law, the law of civil wrongs, is primarily judge-made law. But up until about 2012, it was kind of an American phenomenon primarily to recognize multiple novel torts. So this since a case called Jones v. Siege, which came out in 2012 from the Court of Appeal, there have been a couple of cases, actually many cases out of trial courts across the country where judges have created novel torts. So this is one of them. This is perhaps the most high-profile case, but there's other cases where they recognize torts like torts of harassment, tort of internet harassment, which have all been controversial in their own right as well.
Anthony, we've got about a minute. What is the test for this new tort that the court created here?
So what Justice Mandani did was she took the definition of family violence from the Divorce Act and she applied it in this context. So there's a three-part test. First, the conduct has to be there has to be violence or threatening. The second, there has to be a consistent pattern of coercive and controlling behavior. And then third, there has to be sort of fear for the plaintiff's own safety or the safety of others. And I think there's some controversy surrounding whether that was the appropriate application. I think there was questions by the Court of Appeal that was not the proper application. That should only be used in the context of parenting plans and that sort of thing,
Right.
not the financial circumstances.
Now, we've got to go to break now, but when we come back, we're going to look at what the Court of Appeal found about this. We'll be right back. Welcome back to Canadian Justice, where we're discussing the case of Ahluwalia and Ahluwalia headed to the Supreme Court about the new tort of family violence. Now, Stefan, the Court of Appeal of Ontario took issue with the lower court's creation of this new tort, family violence. So maybe you can walk us through some of the Court of Appeal's reasoning about why they thought that this was not, that this new tort should not have been created this way.
Right. So the biggest issue with this case was that the novel tort, the Court of Appeal found, and frankly, I think it's implicit in the trial judge's reasons that she also found, that there was really no reason to recognize this tort, especially on the facts of the case. So the judge at trial found that this new tort of family violence was actually overlapping on the facts of the case with existing tort called intentional infliction of mental suffering. So that existing tort was made out. There was really no reason to create this new tort of family violence. And this is essentially the line of argument that the Court of Appeal accepted, saying, well, you can't just create new torts because you think that this is an issue that is, perhaps of particular social importance, but there are already mechanisms in place under existing tort law that provide the victim here with redress. So why would you go about creating a new tort?
No, Anthony, one of the things that I've spoken to some other family lawyers about in this case, and we've done other episodes about this case, and that I've heard is that, and it was in the reasoning too at the lower court, that this is in part about the streamlining of processes, that having simultaneous claims for the existing tort of infliction of emotional harm, or just having a separate claim for civil damages simultaneously with your family law claim. I mean, it's a burden on the courts, it's a burden on the individual litigants in the case. It's better to streamline the process. What insight can you give me into that experience as a family lawyer, as well as what the courts have said about this?
I think it makes practical sense that you would just have all of those issues dealt with in a single proceeding. From the litigant's point of view, that person who's making the claim is not likely to have the resources to pursue two separate court proceedings. Oftentimes, legal aid, if they're on legally aided, wouldn't fund a civil proceeding necessarily. And as we know, the courts are backlogged, like in Superior Court of Justice in Brampton, where Justice Mandani sits, you're looking at dates a year down the road. So, like, let's just cut to the chase and be done with it. I think the cynics will say that this is going to open the floodgates, and I think that was something that counsel for the father said during the trial was that this is going to open the floodgates for everyone and their brother to just make these non-meritorious claims of family violence. But if you read the decision closely, it was a pretty high test. It's not just any sort of claim of domestic violence. There has to be credible evidence. It has to be repeated, and so on. So I don't think there should be any meaningful concerns about that. It makes sense. Having said that, in my practice, it almost never happens. I've rarely had files where anecdotally that you would raise a tort claim. So this could be helpful perhaps for the family bar who maybe aren't as familiar as the personal injury bar or other civil litigation practitioners with torts and how to quantify damage, and so on.
Stefan, I mean, I do understand from a practical point of view this concern about streamlining processes. But is it necessary to recognize a new tort in order to achieve that streamlining goal?
Well, no. The Court of Appeal, and I don't think this was particularly controversial on appeal, really, the streamlining of the process. The Court of Appeal affirmed the trial decision on this point. And, there's some possible issues to work out, but I think it just makes sense on a procedural level that if you're bringing a claim between the same parties, that if one of the parties has a tort claim, that claim should be brought in the context of the same court proceeding. You don't need to recognize a new tort to do this. And the Court of Appeal was pretty clear that you could bring existing torts, so assault, battery, intentional infliction of mental suffering, and other things. in that context.
So we've got about 30 seconds left. One of the things the Court of Appeal emphasized, Stefan, was the priority given to statutory claims over tort claims. What effect do you think that had on the outcome?
In this case,
Yeah.
none. None really. In other cases, it might, though the court's pretty clear, I think, that tort claims are different from, say, claims in contract or claims in property, which overlap directly with the statutory distribution of property scheme that we get under the Divorce Act, right? So, for the most part, I don't think that this is going to be an issue.
We've got to go to commercial break now, but we will be right back. And we're going to be discussing how findings of abuse in family law cases differ from the criminal law. We'll be right back. Welcome back to Canadian Justice, where we're discussing the case of Ahluwalia and Ahluwalia headed to the Supreme Court about a new tort called family violence. Now, Anthony, in this case, there was this finding of a tort of family violence. There were also charges against the husband related to criminal offenses that he'd committed against the wife. Maybe you can explain what role the existence of criminal charges might have in a family law claim, including when there's something like this new tort of family law violence. What relevance do those charges have on the proceedings?
Well, in the lower court's decision, the court took the position that not to say the charges were irrelevant, but they weren't given any weight because the charges were still before the court and there hadn't been any conviction. Practically speaking, the family court there's a lower burden. It's the balance of probabilities. So it's a little easier to persuade a family court judge that a criminal event occurred as opposed to a criminal court judge. Just because somebody is charged with a criminal offense, even if they're acquitted, there could still be a finding that the allegations occurred. And I think that's what happened in this case, that even though the husband was not convicted, he was just charged, the court was persuaded by the wife's testimony because the court believed it to be credible.
Now, Stefan, one of the things that is interesting to me about this case is that there was this really large award of damages, or what I would consider a large award of damages, $150,000 for this tort of family violence. I mean, how frequently do you think that this would come up when divorce or separation proceedings involve splitting a shrinking pool of assets generally? How often do you think it is that there would be this pockets deep enough among the litigants for someone to claim for 150,000 in damages? I mean, are we in the realm that there's really only a small percentage of the population that is actually going to have access to this tort? Or could this be something that maybe a home insurance policy might cover? Because I know that there can be all kinds of unusual situations where your home insurance policy might come into play. Would this perhaps be one of them?
So there's a lot to unpack there. So I'll start with that last bit, the insurance claim. What's interesting is that this is an intentional tort, and usually most insurance policies will exclude liability for intentional torts. So whether this new tort is recognized or we go with the Court of Appeals approach and just use the existing torts, those are all what's called intentional torts. They're not negligence. And usually most insurance policies will refuse to cover that. And there's quite a bit of case law on this that kind of affirms their right to do so. Um, the other issue is, well, even in this case, do we know that the husband actually had the pockets to pay for this? This is coming back to your last question with the sort of primacy given to the statutory distribution of property scheme. What the court is saying, Court of Appeal is saying, is do that first, and essentially, if there's any money left over, then you can consider awarding it in damages if there's a tort. Now, this isn't exceptional. This is how torts just generally work, right? I can sue anybody in the civil claim, and if they have money, great, I can get that money from them. But if they don't, then that's the end of it. That's the nature of a civil claim. It's different from criminal liability in that sense. The point is to obtain redress for the wrong that someone else has caused me. It's not about punishing the person for committing a crime.
So, Anthony, what are your thoughts on this? I mean, you're a family law practitioner. You've said that it's unusual for claims of tort to come up in family law proceedings. What do you think the practical implications of of either any result at the Supreme Court, whether the tort is upheld or whether it's overturned? What would be the on the ground implications be for families dealing with abuse?
I think it would give family lawyers another tool in the toolbox to use to even the playing field in situations where there's domestic violence. We know that more often than not, the victims of domestic violence are less financially stable than the perpetrators. So that would certainly be an advantage. But at the end of the day, it depends on how much money is in the till. In this case, there was a house, and the court ordered that the wife would receive the entire value of the equity in the house plus a little bit more as part of the tort award and the equalization award. So I think that there would, if there's no money, then is it worth pursuing a tort claim? Probably not.
Yeah. We've got to go to commercial break now, but we'll continue this conversation when we come back. Welcome back to Canadian Justice, where we're discussing the case of Ahluwalia and Ahluwalia headed to the Supreme Court about a new tort, family violence. Anthony, I'll start with you. What do you think the benefit is of finding this new tort, and do you think there are downsides to creating it?
I think the upside is that perhaps it becomes a more obvious avenue of relief that family lawyers will seek that they normally don't seek. I wonder if there would be legal aid funding for litigants that are being represented by counsel through a legal aid certificate, that they could pursue those claims through that legal aid certificate as opposed to hiring private counsel. The downside, I suppose, the downside would be that there's always unscrupulous people around, and there's going to be unscrupulous people that want to make whatever claims and throw them against the wall and see what sticks. So I think there's going to be people like that, but I think, as I mentioned earlier, that seems to be the exception. In light of those who are going through those incidents of domestic violence, I think there's value in extricating yourself from that rather than making some sort of trumped up claims.
Stefan, what do you think? The upsides and downsides to finding a new tort in this case?
So I'm quite critical. If you've not guessed, I'm quite critical of the trial judge's decision in here, especially at least the part recognizing the novel tort. So I don't think there's any real benefit to recognizing this. The existing claims, especially the way the tort was crafted, the existing claims are more than adequate to redress the wrongs alleged here, or recognized here, in fact. And the downside is this: so you now have a tort of family violence that completely covers other claims. It's overlaps with other claims. But because it's a separate tort, you can now develop it in a way that is sort of different. And we have some of this in the arguments that the plaintiffs or the interveners made at the Court of Appeal. What they're looking for is a different standard applied to what are effectively assault, battery, and intentional infliction of mental suffering claims in the family law context. Now you're starting to treat parties differently for essentially the same kinds of civil liability. And that raises concerns for me of incoherence and, frankly, injustice in the way that we're treating different claimants differently.
And Anthony, one of the things that you mentioned at the beginning of the show and that stood out to me about this case was that at trial, the wife in this case was self-represented. So I know that it's more common in family law disputes to be self-represented than perhaps in other areas of law. But can you talk about how common that actually is, and maybe how unusual it is that she had the success that she did at trial court, given that she was self-rep?
I I think it's unbelievable that she represented herself on an 11-day trial and was successful and created a precedent. Like that's almost unheard of. Unfortunately, it's very common for litigants to be self-represented in family court. A lot of family court litigants don't have the resources to retain counsel. They may start out with counsel, as was the case in this matter, and then for one reason or another, They have to part ways with that counsel. Oftentimes, it's they simply run out of money. An 11-day trial is a massive expense. So it's unfortunately that's just the reality of how the litigation system is set up.
So, Stefan, this is now headed to the Supreme Court. What do you think the main issues there are going to be in this case?
Well, the main issue is the one we've mostly been discussing, which is the novel tort and whether it should have been recognized. I think that's pretty clear from the way that it was pitched. I mean, the Supreme Court sometimes does weird things with the cases it takes on leave, so who knows? But I think that's money should be on that. Now, there's another issue, which is when should trial judges or lower courts recognize novel torts, period? Because
Hmm.
this has come up, like I mentioned earlier, come up a lot. So another thing that the court is probably going to want to address is just the framework for that, because the existing framework is kind of a mess. It's drawn from a dissenting opinion at the Supreme Court in a 2020 case called Nevson. So the court will probably want to weigh in on that, and hopefully it'll get assistance from counsel on this. Hopefully.
Oh. I mean, the Nevson decision, we could do a whole show on that as well. Well,
Yes, we could.
and Anthony, Stefan, thank you very much for coming on. It's a really fascinating case, and I think it's important to also keep victims of violence in our mind when we talk about issues like this. So if you are experiencing family violence and you're watching this, please reach out for help. That's all the time we have. Thank you so much. We've heard today about the new tort of family violence in Ontario and the case that created it, which is headed to the Supreme Court. Does the law need to develop to recognize the unique harms of people, largely women, living with the consequences of physical abuse? Or did the court go too far in creating a new tort when existing legal remedies can be used? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.